that I'm actually reminded to myself too to set us recording. So we are now recording this webinar. Please, if you are not speaking, we ask you to make sure you are on mute. If you have any questions for today's presenters, please feel free to put those in the chat box and we will get those answered for you. So with that, Eric and Anisa, I will turn it over to you.
Thank you very much, Corey. There are a lot of you on today's call, so Corey's suggestion to put questions in the chat box is great, but sometimes it's difficult to wrap up multiple questions into one quick chat. It's also okay if you want to raise your real hand or raise your virtual hand through Zoom. We like to tailor our presentations as much as possible to directly answering your questions because we know that is the most relevant way to deliver information to you. So please feel free to interrupt us. Given the nature of Zoom, as we are sharing our screens with all of you, we will only be able to see a couple of you at a time, so it may be hard to get our attention, but Corey's gonna be keeping an eye on things. And again, you can always turn your video on, wave your hand, or just try and jump in and interrupt. Title IX is a very important topic, but you know what? I just realized I should introduce myself and my colleague, Anisa. I'm Eric Stevens. I'm joined by my colleague, Anisa Pillai. We are attorneys. We are proud and happy to be invited by SSDA to give you all an update. We do updates on various topics. Today, we're going to be talking about Title IX. I will also put in a plug for SSDA's policies. If you aren't familiar with these yet, SSDA partnered with my firm and we prepared template policies tailored to small school districts, which are really the only policies you actually need because some law says you must have a policy on fill in the blank. There are hundreds of things you could have policies on, but we worked with SSDA to create these open source policies for you, their members, to give you a foundation. Maybe they are the only policies you need. Maybe you want to consider making it the foundation of your policies for your district. Today is not a pitch for policies. We're not going to get into that in great detail. There will be another webinar coming up later in September for more details on the policies. But I do bring it up because one important policy is a Title IX policy. And we have just made some small tweaks to the existing SSDA Title IX policy as a result of recent changes to Title IX, which we're going to talk about today. I'm going to dive right in. I'm going to give a little bit of background and a refresher on Title IX and some of the key definitions. Anisa is going to guide us through these most recent changes that have just gone into effect about a week ago. Then we have several other key topics that, time permitting, we will go through. But again, we hope you feel comfortable interrupting us with your questions. We have far more slides than we can possibly cover in 3 hours today. Just kidding, we're only talking for an hour. Far more slides than we can go through. We are going to provide these slides to you, or I should say Corey will provide the slides to you when we're done. So no need to try and copy down what you're seeing. And again, we're probably going to run out of time. That's okay. We would rather provide you more materials in writing than we have time to cover than provide you with less. So without further ado, I'm checking chat. Will this recording go out to listen to again later? I think the answer is probably yes. Corey will be able to definitively answer that soon, but I'm going to share my screen and we will get going. Here we go. Top tips for navigating Title IX. Oh, there we go. Quick refresher, I think we're all familiar with Title IX. That's why you're here on today's webinar. It is a federal law that applies to all of our school districts. If any of you are charter school leaders, it applies to any charter school that receives any federal funding, which I believe in one way or another is going to be every charter school. It is enforced at the federal level. We have a lot of very similar and parallel state laws, which may be enforced through our own Office of Equal Opportunity. But today we're focused on Title IX. Title IX tends to set the floor. And we've seen in recent years, California considered passing some laws that were ultimately vetoed to try and enshrine some old Title IX guidance from the Obama administration. That did not happen. So these updates we're talking about today, they just went into effect. Obviously, politics, times change. Under President Donald Trump and Education Secretary Betsy DeVos, we've seen them walk back previous Obama era guidance. So generally, big takeaway for all of you, you've got a little more flexibility, and the requirements of what you have to do and when you have to do it have been eased somewhat. But as we get going, remember, Title IX is much broader than sports. A lot of people think of Title IX in the context of having an equal number of sports opportunities and extracurricular opportunities for boys teams and girls teams. It's a lot broader than that. It prohibits discrimination based on sex or gender expression, which can come up in all sorts of different contexts. It also prohibits sexual harassment, and the definition of sexual harassment is quite broad, and it has been tweaked slightly. But 5 main areas of enforcement: it's sex-based harassment, which could be sexual harassment or sexual violence. We're going to talk about this. Bullying, pregnant and parenting students' rights, and of course, athletics. As with so many of these laws, there's also a retaliation component. If someone makes a complaint that they were discriminated against, we have a duty to protect them from retaliation. And if they allege that we didn't, that can also be additional grounds under Title IX for a complaint. So sex-based harassment, I mentioned that it's a pretty broad definition. It can take multiple forms. We have to protect students and staff from harassment that could be coming from other students, other staff, or even third parties who visit our school. What is sexual harassment? Quid pro quo sexual harassment, classic sexual harassment. By this point, we should all be familiar with that, what it is and why it's not okay. But there's certainly an evolving understanding of what is and is not appropriate. And sexual harassment, it can also take the form of unwelcome advances, requests for sexual favors, the quid pro quo. What we increasingly see in complaints and things that we have to investigate, which leads to very difficult factual questions we have to grapple with, is allegations that there's some sort of unwelcome conduct that's made someone uncomfortable. We hear hostile work environment all the time. We hear the word harassment all the time. There's the common everyday sense in which we use harassment or a hostile work environment, but then there are narrower, more specific legal definitions. So sexual harassment, it can be legally actionable sexual harassment when it's unwelcome conduct that a reasonable person is going to find severe, pervasive, and offensive, such that it denies the victim equal educational access. What does that mean? Denies the victim equal educational access. That's going to be similar to the analysis you would do in a hostile work environment claim. It's going to be a question of, is the person so impacted emotionally and mentally that it is causing them stress, causing them anxiety, making them fearful to go into the workplace or into school, such that it's having an impact on their ability to go to school and access their free, appropriate public education. Sexual violence, this is a catch-all term for what we would typically call sexual assault or rape. You can see there's a list of any sort of physical violence of a sexual nature falls under sexual violence. There is a new recognition under these Title IX changes that dating violence, domestic violence, and even stalking now also fall under the purview of Title IX. I sincerely hope that in your roles as school leaders, you never have to deal with any allegations or confirmed incidents of any of this happening. But stalking is now officially a subject of Title IX complaints. If someone complained they were being stalked, we would treat it as a Title IX complaint and pursue it accordingly. It's also encompassing gender-based harassment. This is based on someone's actual or perceived sex. This can take the form of bullying. We need to keep in mind that when there's a bullying issue, it could also have Title IX implications depending on who's being bullied and why. I'm going to toss it over to Anisa in a moment to talk specifically about the changes. But before I do, let me go back. Gender-based harassment and sexual harassment, it's been recognized by the Supreme Court that sexual harassment can take the form of simply harassing someone or bullying someone for not conforming to gender stereotypes. So a man could be sexually harassed by other men because they're harassing him and saying he's essentially effeminate or not a real man. As we've all been dealing with issues of transgender students' rights and gender identity and helping students navigate those very difficult personal situations, that also gives rise to a lot of contexts many of us didn't used to have to confront and deal with, in which someone could be harassed because perhaps they present as male, but their birth certificate may have said female, and people may be harassing them for that. Especially if they are changing their gender identity while they're in school, they can be a target of bullying and harassment. That falls under Title IX, those sorts of complaints and concerns. Before Anisa dives into more specifically the changes that have just come out, do we have any questions initially? Because again, it's hard for me to see you. I'm gonna pop out my menu here. Anybody want to jump into chat or wave their hand? Okay, I'm not hearing or seeing anyone. So I'm going to attempt to pass over control to Anisa without messing this up. Anisa, you ready?
Yes.
Okay.
So I'm not seeing the slides anymore. Is everybody else seeing the slides?
No.
I just stopped sharing so that you can share and you can move the slides at your own pace.
Okay.
And you should be able to.
Okay, give me just a couple seconds here to try and figure out how to pull up the slides on my end.
I hope everyone's had an all right time reopening school. This is a very difficult time. Just in talking to clients, I think most of us are opening up in distance learning and have started. I know of one client who's launching in-person learning in 2 weeks.
So I'm sorry, guys. I'm not seeing how to share the slides on my end. Eric, would you mind
Okay,
just
I'll go
pulling it
back.
up?
Sorry, there we go.
Okay, no problem. Okay,
All right,
great.
apologies everyone. And how many times has this happened in the last 6 months since everything's gone online?
Yeah, I'm not the techiest of people, but hopefully I can talk about the Title IX changes. So obviously there's been changes that have just recently happened in August. Just to give you guys a little bit of background, under the Obama administration around 2011, that administration made several significant changes to Title IX that were in effect for several years. Obviously, when Trump became president, the Trump administration and the Department of Education back in 2017 decided to roll back those changes that were made under the Obama administration and made an announcement that they would be coming up with their own new rules and new changes to Title IX. So the last couple of years, these rules have kind of been an ongoing process. The administration's been receiving public comment. They've been holding meetings with various stakeholders to kind of refine these rules. And finally, they were released in May, and they took effect, like Eric was saying, about a week ago on August 14th, 2020. So I'll kind of go into the changes. They've changed some definitions. They've created a lot more procedural safeguards for respondents. So there's several changes I'm going to talk about. So the first one is just, when do schools need to respond to complaints of sexual harassment? So just some background, under the prior administration, schools were required to respond to sexual harassment that they had actual knowledge of or that they should have reasonably been aware of. even if they didn't have actual knowledge of that. And the reason I think that the prior administration did that was just to ensure that schools couldn't kind of, stick their head in the sand, metaphorically speaking, and not be actually aware of sexual harassment that was occurring on their campus, and then not be liable for that harassment. But now the rules have changed. So schools are required to have actual knowledge of sexual harassment in order for that to be considered a violation. So just for some background, for colleges, certain individual employees are going to be made mandated reporters of sexual harassment. However, for elementary schools, for K through 12 schools, every single employee is going to be a mandated reporter in terms of Title IX to report sexual harassment, because younger kids, they can't be expected to know who they're supposed to go to report a Title IX violation. That doesn't seem reasonable for younger kids. And then also most schools and most states require teachers to be mandated reporters of sexual abuse anyways. So that kind of made sense. In terms of the location for sexual harassment, schools are required to respond to sexual harassment that occurs in the school's educational program or activity. So basically in situations that the schools had exercised control over the respondent or the situation where the harassment occurred. Previously, under the Obama administration, schools were required to investigate all complaints of sexual harassment, regardless of where they occurred, even if they occurred off campus, just to determine whether they had some sort of impact on campus events. But that's changed now. So now it's just events that are occurring in association with an on-campus event. One concern with this is that it doesn't necessarily cover events that happen outside of the United States. So for study abroad programs, Title IX might not protect students, but that just might be one concern there. So supportive measures. So these just mean, what is the school supposed to do in order to help a victim when they come forward about sexual harassment? So regardless of whether a victim wants to make a formal complaint, these are just some of the things that the new rules list out: counseling, changing academic deadlines, modifying a student's schedules so they don't have to see a perpetrator. Just in comparison, under the Obama administration, they listed out a lot of different remedies that a victim of sexual harassment could seek out, that the school was required to provide. This could include things like free medical care, tutoring services. They really just took a holistic approach to providing remedies for the victim. And they also provided a lot of remedies just for the campus at large to address sexual harassment. So things like offering counseling to anybody at the school, having somebody on call who had to talk about sexual harassment with students, who was on call throughout the day to deal with issues that came up. So instead of taking this really holistic approach to prevention and to addressing sexual harassment in the whole community, it's now really focused on, well, what can the school do to help this particular victim of sexual harassment?
I'll interrupt briefly. We know this can be a challenge for a small school district or a small charter school. You're small, you don't have the headcount that a large district has, but the important thing to know is you're required to still provide some sort of supportive measures. And I think counseling, just some offering extra sessions with a school counselor, that is always something that we can do. Even if you're doing an investigation, you don't know what your results are yet. Or even if you reach a conclusion that you're not sure that anything actually happened, or what's alleged to have occurred, it happened off campus and it's not a situation that you can discipline anyone for, you can still offer the victim, the person bringing the complaint, additional counseling and support.
So the new rules also made they added a lot of procedural protections for individuals that may be accused of sexual harassment, as well as just procedural protections for both parties. So a couple of the big ones, there's now a presumption of innocence that is required now under Title IX. So before, under the prior rules, there was no requirement that the school presume that an individual being accused of sexual harassment was innocent in the way that you would assume that in, you know, a criminal court. So now this is a little interesting, because if you have somebody complaining of sexual harassment in the past, maybe you would want to kind of move that perpetrator, change their classes, you know, to help separate the two parties. But now if we're presuming that that perpetrator is innocent, you don't want to necessarily place a heavier burden on that individual before the whole process has played it out and found that person guilty of sexual harassment. So we want to be careful of making any changes that would place a heavier burden on the person accused of sexual harassment. Under the Obama administration, in terms of the standard of evidence, it was the preponderance of the evidence standard, which basically means if somebody felt that the sexual harassment occurred, it was 50% likely to have occurred plus a feather. So like 50.1%, 50.5% likely that the sexual harassment occurred, then that person would be found guilty. Now schools have the option to choose the higher bar, which is the clear and convincing evidence standard. It is a higher bar to meet. Schools have the option to choose the two, but whichever evidence burden they choose, they have to apply it to everybody, even if a teacher or an employee has been charged with sexual harassment. So this might just become tricky for schools if there's a collective bargaining involved. In order to change the standard of evidence, you would have to go through that collective bargaining process. So for a lot of schools who are dealing with that, it would probably make sense for them to just continue to use the standard that they currently are applying. The last one.
Sorry, I'll interrupt. As a quick note, the SSDA template policy, it doesn't talk about evidentiary standards. So that's something that if you're using the policy, you can consider whether or not you want to add language to adopt that. But you don't necessarily need to actually say in your policy, here's the evidentiary standard we're going to use in investigating these complaints. I think the reality is you've got a complaint process. You also have your internal discipline process, which is spelled out in Ed Code. And to the extent you can keep those things on the same page, I think that's the best, because we wouldn't want to use a different evidentiary standard in determining whether or not a complaint is substantiated than we would in determining whether or not, say, expulsion or other discipline is warranted against a student. That would just lead to potentially very difficult, very awkward situations in which you could say, well, there's not enough evidence, or there is enough evidence under Title IX to substantiate this complaint. Therefore, we're going to do some things to help the complaining victim. But on the other hand, it doesn't meet our evidentiary burden, or it does, the opposite, under our discipline policies. So we're not going to take any action against the student who was accused of having committed the sexual harassment or the sexual assault, or you name it. So try and keep things together, which again, in general, one of the approaches with the policies was to try and keep things as simple and straightforward as you are legally allowed, because you have enough things to worry about. And we don't want you to get tripped up with multiple processes and multiple standards and multiple different ways of doing things for a bunch of different individualized situations. The fewer things you have to worry about, the better. And let's ask real quick, we're about halfway into the hour. Any questions yet? Does anyone have questions or concerns? Anything not clicking, or does anybody have a specific factual situation they've encountered where they weren't sure what to do? All right, I'm not hearing or seeing anything. Okay, we'll keep going. Okay,
we can just move on to the next one. Yeah. So to continue just with this new grievance process, so more protections for both parties, really. So the first one is schools must send written notice of the allegations to both parties upon the receipt of a formal complaint. In terms of providing notice to the respondent, you want to make sure that that notice or the allegations are provided with enough time for the individual to prepare for an interview that's probably going to be coming down the line if a formal complaint's been made. And then one of the other requirements is schools must provide a copy of the investigative report to both parties, which summarizes the evidence before the hearing. Again, the new rules really require a school to give a respondent enough time to adequately prepare for any hearing that may be happening. So we'll kind of talk about a requirement for colleges and universities to conduct hearings in a second. But this kind of almost seems like a cross-examination process that's happening like on paper, that schools, including K through 12 schools, are required to comply with. So basically, after an investigative report's been provided to both parties, but before a final decision's been made, schools must give each party the opportunity to submit written questions to the other party. They have to receive answers to those questions, and then they're allowed to ask additional follow-up questions from each party. So even if a K through 12 school, you don't want to require a hearing, this kind of written process ensures that the respondent has an opportunity to almost like cross-examine somebody in a written form. So kind of what I was talking about in terms of hearings. So this is a more controversial part of the new rules. In terms of colleges and universities, like I was saying, they're now required to hold live disciplinary hearings in sexual misconduct cases, and they are required to allow cross-examination of witnesses. So this is not a requirement for K through 12 schools, but it's an option that they can choose to adopt. Just as a comparison, under the Obama administration, live hearings, they were not prohibited, but they were certainly not encouraged. And cross-examination of witnesses, especially victims, was also not encouraged, I think probably just to avoid potentially re-traumatizing victims or re-traumatizing witnesses. So that was a big concern prior to the new rules. So now we have this new option to hold hearings. In terms of elementary, go ahead.
I was going to interject that, again, Title IX is the federal law, and it's running in parallel with our state ed code sections on discipline. If you haven't had to go through this before, I am glad to hear that, but ed code allows us in situations involving allegations of sexual harassment or sexual assault, it does allow us to a certain limited extent to protect a victim when it comes time to hold an expulsion hearing or a suspension hearing, a hearing on discipline. We cannot base, for example, an expulsion decision. It can't be based entirely on hearsay, which could include written statements. So if you find yourself in a situation in which you need to hold an expulsion hearing, to be effective, there needs to be some sort of testimony from witnesses, which in a sexual harassment or sexual assault case means it's going to be the victim, and that can be very tough. But we can create situations, which has become much easier due to, ironically, COVID-19 and Zoom, where the victim, if they're uncomfortable, they could be in another room and we could just broadcast them into the room using something like Zoom, where a representative for the accused is going to have an opportunity to ask them questions and essentially to cross-examine them, but they don't necessarily need to be in the same room as the person they're accused of. In general, these situations can be incredibly difficult, and there's so many sensitivities involved, especially if you haven't had to deal with these types of issues before. Then I would say the first time you get one of these complaints, it's a great idea to check in with your attorney and get some guidance on how to handle these situations, how to prepare for a hearing if it needs to go to a hearing, and things like that.
Yeah, and I'll just add, just in terms of Title IX, there are some protections for witnesses and for victims. Just for example, the individual accused person cannot cross-examine the victim directly. It would have to be that person's representative, like an attorney or somebody else. Also, questions have to be screened in advance to make sure that they're appropriate, they're relevant. You know, the person can ask about a victim's past sexual history. So there's a couple of protections built in to Title IX now to protect victims. This is kind of just like a high level like overview of some of these requirements. One other thing, just now in terms of parents or rights, so a parent or guardian is allowed to file a complaint on behalf of their minor child. And then schools are required to notify parents if there have been any allegations or complaints against their child.
Once again, questions or, well, any questions or any comments from the audience before we move on? So this is wrapping up things that have just changed and things that are now a bit different under Title IX. Nobody? All right.
Okay, so I'll quickly talk about just responding to sexual harassment when a school does receive a complaint. So, you know, if an investigation ends up revealing that sexual harassment did occur, that it did create a hostile work environment, then schools are required to take steps to end the harassment, obviously to eliminate any sort of hostile environment or hostile culture that's existing, and to try and prevent reoccurrence from happening. So a couple of options: separating the accused harasser and the target, though again, kind of like what I mentioned before, a school wouldn't want to place a heavier burden on the accused under Title IX than they would the victim. Providing counseling, or then obviously taking disciplinary action against the harasser, just depending on whether that was appropriate. Discipline must be appropriate to the age of the harasser. For example, the Education Code prohibits suspension or expulsion for kiddos in grades K through 3 for sexual harassment, just probably because the law is recognizing that they might be too young to, you know, understand the consequences of their actions. But counseling might be appropriate for a victim or a perpetrator of sexual harassment at that age.
I'll tackle a couple tips. Tip 4, don't inadvertently penalize the complainant, the accuser, the person who's saying they're a victim. And these recent changes that have really stressed the presumption of innocence for the accused can make it a little bit more difficult, and I'll explain why. We want to make sure that our efforts to protect the accuser don't inadvertently penalize them. So up until 2 weeks ago, we would always consistently say it can be an appropriate response while you're doing an investigation to separate the students in the form of moving the accused, moving the person who's accused of the harassment or the assault. That is, I think that's a little more ambiguous now because of the direction the federal government's taking Title IX. But you definitely don't want to move, especially not involuntarily move, the person who is the target of harassment. So it can be a very difficult, sensitive situation in which you might want to offer the accuser the opportunity to switch into a different class. But if you make offers like that, if you offer anything which is a change to how they've been going to school and what classes they've been taking and things like that, you need to be really careful, because we definitely don't want to pressure or encourage them to do it. We certainly don't want to involuntarily move the accuser, because then we're penalizing them for coming forward with a complaint. And that is ultimately a type of retaliation, even if it's inadvertent. Oh, and there you go, retaliation. Again, we always need to remember that we have to protect people from making complaints. We can't intentionally or inadvertently retaliate against them because they've made a complaint or because they've participated in an investigation. Anisa?
Sure. So like Eric mentioned earlier, bullying can be a violation of Title IX as well. Bullying is just kind of a term to describe things like hazing, teasing, you know, not necessarily based on sex or sexual orientation, but just kind of that typical bullying that you see. It could include cyberbullying with social media and text message and Facebook. Like, kids are really using social media to bully each other these days. So bullying is kind of a really wide, encompasses a really wide variety of conduct.
Yep, you have to really get into the substance of how is the person being bullied, and if the bullying could be taking the form of sexual harassment or gender-based harassment. It could be taking the form of teasing about how they express their gender. It could be teasing about their masculinity or their femininity. Those things become sexual harassment. So you may just hear from a student or a parent, my kid's being bullied, and they don't actually make a formal Title IX complaint. But then as you dig into it, you realize, I think there actually is a Title IX issue here. And again, once we have actual knowledge that harassment or sex-based discrimination may be occurring, we need to respond under Title IX, the way Title IX requires us to respond. Yep, and we've covered that. And number 6, it's always helpful to just remember a quick refresher. What are transgender student rights and protections under the law? California has passed several bills to protect transgender students. The most common one is what we all oftentimes talk about as the bathroom bill. We've got the School Success and Opportunity Act, which allows students to use the restroom and participate in activities based on their gender expression, regardless of what it said on their birth certificate. If they identify as female or they identify as male, they can use the corresponding locker room or bathroom. And in the first several years, I think we heard a lot of concerns, people saying someone who doesn't actually, like a boy who doesn't actually identify as female, could just say that because he wants to go into the girls' locker room or the bathroom. We heard a lot of people express those concerns. I've never heard of that actually happening. We're getting some feedback. So if somebody's trying to speak up to jump in and ask questions, please interrupt. I'll give you a second. Nope, okay. So the key here, hopefully you've received some guidance on this previously, but it never hurts to review. One of the keys here is try and provide a private restroom, like a single person restroom on campus that students could use, and any student can use that bathroom. So the reality is, let's say you're a middle school and you've got a locker room. If a student who identifies as female has been using the girls' locker room, if they're uncomfortable with the fact that a transgender student could be in the locker room with them, that student can go use a private restroom to change. If somebody's uncomfortable with the fact that a transgender student might be sharing the same bathroom as them, any student can go use a private restroom on campus to use the bathroom or change. That is the best approach. That is a permissible approach. It is allowed under law, and it's effectively required because we need to provide that to anyone. So everyone is ultimately on an equal footing. The student who wants to use facilities consistent with their gender identity, and another student who may not be comfortable with that. They have options and they have alternatives. Sports participation, I don't know if any of you have had to deal with this yet, but CIF has an appeals process, and ultimately a student just submits information and documentation to CIF and says, I identify as female, I want to play on the girls' team. And CIF should enforce CIF. And we can reach out to CIF for assistance, for support, for guidance, but CIF should just grant it without fail. It's not a decision that we need to make. We just get to say, it's up to CIF, here's the process. since we had the all gender restroom bill passed a couple years ago, those single use toilet facilities are supposed to be identified as all gender anyways. So again, you can comply with the other transgender student rights bills by making sure you have also complied with the all gender restroom bill. The key is most of your single use facilities have historically just been for teachers or staff. Again, if you've got multiple, I know you may have a very small campus, but if you've got multiple such restrooms, make one available for students. Number 7, check your online posting. You need to have a prominent and conspicuous online posting which lists key information. It's got to be on your website. This is an easy one to mess up because websites change, times change, things move around. You may not even be the primary host of your website. It may be your county office of education who helps with that, but there's a checklist we need to comply with. Again, the SSDA template policy includes a template posting to try and make that easy for you. And it's got to include all the basics, well, certain key basics of rights under Title IX, how people file complaints. So questions, we've stopped a number of times. It's been a quiet audience today, and I get it. You're all either have just started school or you're gearing up for it. You have a lot on your plate, but it is 3:45 and we can open it up for any and all questions people have. Otherwise, I'm sure none of you will complain if we wrap up early today. So I'm going to stop talking for a moment and let other people jump in.
Not seeing anything come through chat, but again, as
All right.
Eric mentioned, we're a small group, so if you want to take yourself off mute and verbally ask your question, you can do that as well. Starting to think you guys did such a good job that nobody has any questions right now.
That's what I'm going to tell myself. All right, well, Corey, do you have anything to say as we wrap up?
No, just thank you both so much for such a great webinar. I know this is something that we've had requests from quite a few members for. So this has been wonderful. And again, as I mentioned in the chat, a recording of this webinar will be made available on our YouTube channel probably tomorrow, and I'll also send it out to all registrants. And if you have any questions that just kind of pop in your mind after this, feel free. You can always email or call me, and I'll be happy to pass those over to Eric and Anisa and get those answered for you.
Great. Thank you, Corey, and thank you everyone for joining us today. And as Corey just said, don't hesitate to give us a call or send us an email if you've got any questions. Corey will be sending out a set of these slides shortly. Have a great afternoon, and I hope everyone's staying healthy, happy, and safe.
Thank you guys
Bye.
so much. Have a great afternoon, everyone.
Bye. Thanks, everyone. Take care.
Bye-bye.